We're now going to turn from incitement to some of the other issues related to free speech. Specifically, we're going to talk about expressive conduct, right, which is one kind of expression that merges actions with words. We're going to talk about public forums, which are key to the kinds of circumstances under which speech or expression takes place. And then we're going to talk about time, place, and manner restrictions. As we've been saying throughout this unit, although the First Amendment says that Congress shall make no law restricting the freedom of speech, of course, that isn't entirely accurate, right? There are all sorts of factors that have to actually be considered in assessing whether or not speech is protected by the First Amendment. So we're going to look in this voice thread at some of those conditions and the cases related to them. A key idea to consider here is the concept of public speech, right? So we talk about freedom of speech in a kind of general way, but usually what we mean is public speech, right? So that's words that are published or speeches that are made to a broad audience. But there are different concerns at play when we're talking about public expression versus private expression. And especially if we're talking about in-person public expression, like say, giving a speech, right? Or addressing people door to door. So why is public speech different from private speech? Well, because speech in public can cause the potential for breaches of the peace, right? So these might be violence, it might be other types of criminal activity, but basically things that are related to public order. So sometimes certain kinds of speech in public can create this kind of conflict between the speaker's interests and then the state's interests in keeping order. So as we'll see in the cases that we're about to look at, and this actually will be extended into the fighting words cases that will be in the next voice thread, the key to looking at the kinds of regulations that should be on public speech or the limits to public speech are ultimately found in the effects of that speech. So far, I've been talking a lot about speech, right, per se, which we think of as, spoken communication, maybe written communication. But in this voice thread, we're going to look at a broader definition of expression that's going to encompass certain kinds of actions. Let's begin with an example. So here on the slide, I have the South Carolina Clean Indoor Air Act. Most states have some kind of version of this law that basically prohibits smoking indoors, right? So this is obviously a shortened version of it, but it reads in part, and I quote, "It is unlawful for a person to smoke or possess lighted smoking material in any form in the following public indoor areas except where a smoking area is designated as provided for in this chapter. 8. Buildings or portions of buildings and the outside areas immediately contiguous to these buildings owned, leased, or operated or maintained by a public institution of higher learning." Okay, so let's say the College of Charleston. That would be an institution of higher learning that is public, owned and maintained by the state. Let's think about, say, Maybank Hall, where the political science department has most of its classes. So on an average Wednesday, if I walk in to teach Poly 321, I go up in front of the class, and without comment, I take out a great big cigar, and I light that and begin smoking it in front of the class. I would probably be in some trouble for violating the South Carolina Clean Indoor Air Act. Would I have any kind of First Amendment protection for defense for having done that? No, probably not. Now, if we reframe this and say I walk into that classroom and I write South Carolina Clean Indoor Air Act on the board, and then with chalk, I draw a big no sign through it, right? I give a short speech on how this is interfering with my liberties, and how it's part of my basic right as an adult to indulge in giant cigars in the classroom. And then I take out a cigar and I light it up. Is the situation different? Well, in the first case, what we're looking at is criminal conduct, right? So lighting a cigar where it isn't supposed to be lit. And in the second case, we're also looking at that same criminal conduct, but now there is an aspect of expression to it. Arguably, the second example of that is actually expressive conduct as part of a protest. So then I'm going to raise the question, should we treat those two situations differently? Should we treat the expression as like a mitigating factor in the second case? Expressive conduct poses all kinds of problems for the courts. And part of this is because it's very difficult to define, right? So, we all engage in all kinds of conduct. Generally speaking, the distinction between thought and conduct or speech and conduct is really important in constitutional law, right? Remember, if we think back to Reynolds in the freedom of religion unit, there was this belief action distinction. Well, suddenly we are looking at action as not being entirely distinct from, say, expression. So let's think of some examples of what we might consider expressive conduct. So I just gave you the example of maybe lighting a cigar as part of a protest. Other examples that we might think of are, burning a bra, right? So back during the women's movement in the 1960s, during protests, you might see this happen. Other examples, well, as we'll see in the O'Brien case and in Texas v. Johnson, we also see people burning draft cards. We see them burning flags, right? But I mean, there are all sorts of things that people might do as examples of expressive conduct. So I'll post some of these to the discussion board and you can take a look and decide whether or not you think that certain things could be considered expressive conduct. Other examples of expressive conduct may be tearing down a flag, right? So there's a very famous video that was taken actually on the College of Charleston campus of a member of Black Lives Matter jumping over a fence and pulling down a Confederate flag. So that is a textbook case of expressive conduct. But these cases tend to really challenge the courts, in part because the courts do lean so heavily on that belief/expression/action distinction in determining what is punishable and what is not. So we now see these instances of otherwise punishable conduct that take on this much more complicated cast when they're considered not only criminal conduct, but also expressive. So there are some early cases dealing with this. So for instance, Thornhill in 1940 deals with a picket line. What do you think about this? Is marching on a picket line or standing on a picket line expressive conduct? Similarly, Milk Wagon Drivers Union, 1941, there's this question of how much regulation then of the picketing is allowed, right? So if picketing is protected expressive conduct, nonetheless, there have to be some regulations on it, right? So you might see with picket lines, especially instances where you might have shoving, jostling, or attempts to actually obstruct people who are trying to cross that picket line. In Milk Wagon Drivers Union, the court ruled that when looking at what can and cannot be regulated, whether or not there's the presence of violence is key. And so the rationale for this being that the state has a compelling interest in keeping order. And so while the state has to balance that against the expressive interests of the people on the picket line, ultimately that compelling state interest in keeping order is going to outweigh that. So as you'll see, a lot of these cases are very difficult for the court to decide. And we will look in some detail at US v. O'Brien from 1968 and then Texas versus Johnson from 1988. So these are two cases with very similar facts. We have people burning things in protest in public forums, but they're ultimately treated very differently, and we'll delve into why that is in just a moment. Let's begin with US versus O'Brien. So this is a 1968 case. What was going on in the US at this point? Well, the Vietnam War, right? So this was a very unpopular war, and the draft in particular was a very unpopular feature of how the US went ahead with this war. So this took place as part of a protest. This was in front of a South Boston courthouse. As an aside, we're going to talk in just a moment about public forums. Public forums are spaces, right, where expression takes place. But not all spaces are treated the same way for First Amendment purposes. So just as a brief preview, there's a traditional public forum, right? So these are places where historically people have spontaneously gathered to express themselves, right? So when you picture the speaker standing on a soapbox, you might picture them in, say, a park or a town square. Additionally, streets and sidewalks are considered traditional public forums. So these, which are public spaces that have, again, like traditionally or historically been used for expression, receive the highest degree of protection. So the fact that O'Brien is taking part in this demonstration in front of a South Boston courthouse, this is an important detail. Okay, so O'Brien, several others are holding this protest in a traditional public forum in front of this courthouse. And in the course of this protest, they produce their draft cards, show them to the audience, and then set them on fire. So let's just take a step aside for a moment. Now, if you were to see this happen, knowing the context that it's the midst of the Vietnam War, the draft is very unpopular. If you saw this happen just in like one or two sentences, what do you think the message that O'Brien was trying to convey was? My guess is you have a pretty good idea, right? My guess is that you would think, okay, this person is protesting the war, they're protesting the draft. So this is fairly clear what this expression is trying to convey. All right, so O'Brien was arrested, and he was charged with violating a 1965 amendment to the Selective Service Act. So this amendment made it illegal to, and I quote, destroy or mutilate draft cards. All right, well, what's so important about a draft card? Well, remember, this is 1968. We didn't have digital records for everything. You couldn't necessarily do your Selective Service registration, again, like on your computer or from your phone. So paper was more important in 1968, and this is going to end up being important to the government's argument here. So the legal question that arises in U.S. versus O'Brien is, does the anti-draft portion of the Selective Service Act violate the First Amendment of the Constitution? So that's like the anti-draft card burning portion. So does this provision that makes it possible for the state to punish O'Brien for destroying or mutilating his Selective Service card violate the First Amendment? So the court ultimately holds that no, this was not a violation of O'Brien's First Amendment rights. And this is a 7-1 ruling, which is, again, a pretty strong message being sent. So what does the court say about this? A few things. Number one, they say we can't accept the view that a limitless variety of conduct will be considered speech whenever the person intends to express an idea. It doesn't follow that the destruction of draft cards is a constitutionally protected activity. Okay? So the court rejects the idea that any conduct basically can be considered speech. They also reject the idea that expressive conduct is defined by the intention of the person taking part in that conduct. Okay? So they look at this and they say, no, as such, the destruction of a draft card is not a constitutionally protected activity. They acknowledge that they've held in the past, right? So remember those cases I was just talking about, that when speech and non-speech elements are combined in the same course of conduct, then there has to be some sort of weighing, right, between the government interest in regulating the non-speech element of a conduct, right? So this is just the pure conduct. And as such, if there's a sufficiently important government interest in regulating the non-speech aspects of that conduct, then incidental limitations on First Amendment freedoms can be justified, right? Okay, well, let's look at O'Brien again. So what is the government's interest in regulating the non-speech elements of this conduct? Okay, well, the government argues that the state has a compelling interest in conducting the draft, right? Because this is an integral part of the war effort. And so the state's interest in this case is not so much in regulating O'Brien's expression, right? So they deny that that's what they're doing. They say, we are not punishing O'Brien for expressing himself. We are punishing O'Brien for interfering with the state's interest in conducting the draft by destroying this draft card. And so they uphold this part of the Selective Service Act by saying that, no, there is a compelling state interest in ensuring that people don't destroy these cards because we need them as a sort of administrative necessity to conduct the draft. All right, so let's look again at the state interest here. What the court says is that the Constitution grants Congress the power to raise and support an army, right? And they say that this power is, and I quote, broad and sweeping. Right? So they say that issuing draft cards is necessary to conducting this activity. And so there is a sufficient governmental interest in preventing the destruction of these draft cards. Therefore, that outweighs any expressive interest that O'Brien may have. So here we see the court find not in O'Brien's favor. So I just want to tease out a couple of points here. So number one, there's the question of the content of O'Brien's expression. Number two is actually the conduct itself. The government in freedom of speech cases, very much similar to, or as in freedom of religion cases, tries to adhere to norms of viewpoint neutrality, right? So tries to avoid bias. This is a really key idea in freedom of speech. So there's in fact like a viewpoint neutrality doctrine. And what this means is that the government may not, in freedom of speech cases, show any favor or bias, or favor for or bias against any particular viewpoint. So what this means is that the government cannot constitutionally punish O'Brien for protesting the draft, right? So the content of that message, which is protesting the war, protesting the draft, that cannot be the target of the government action. Rather, if the government is going to do something to interfere with O'Brien's expression, it has to be simply aimed at controlling the non-expressive elements of the conduct, right? And so this is a key part of how O'Brien is decided. As I've noted before, this kind of case gives the court a lot of trouble, right? And has had historically given the court a lot of trouble. So here in 1968, in US versus O'Brien, the court lays down some guidelines for determining whether or not conduct is expressive conduct, first, and then second, whether or not that conduct should be given First Amendment protections. So under the rules that come out of the O'Brien decision, government regulation that applies to a form of expression is constitutional if, number one, it is within the constitutional power of government, right? So in this case, the basic police powers of government, protecting the health, safety, well-being of the people. So preventing people from burning things in public, generally within the constitutional power of the government. Conducting the draft, also within the constitutional power of the government. Two, it has to further an important or substantial governmental interest. This language is going to become important later, but I'm just going to kind of preview why that is. So important and substantial government interest is the language that is associated with the intermediate level of scrutiny in expressive conduct cases. So it doesn't have to be a compelling state interest necessarily. It just has to be an important or substantial government interest. However, that interest must be unrelated to the suppression of speech, right? So the third prong of this test is that the government regulation may not target the message. It has to be unrelated to the suppression of speech. And then fourth, if the restriction incidentally imposes, the restriction that the action incidentally imposes on speech must be no greater than necessary to further that interest. Okay, so this language also is probably going to seem familiar because we see this language of necessary means generally appearing with strict scrutiny, right? So if we think back to, say, Sherbert versus Werner. So we see in prong 2 the language of intermediate scrutiny, and then we see in prong 4 the language of strict scrutiny. So this is a somewhat confused decision. Okay, so note, the O'Brien rules don't explicitly require that the regulation be content neutral. However, what we see is that if there's any evidence that the regulation on speech is not content neutral, right, that it in some way treats one message differently from another message, then strict scrutiny is applied, right? And so we're going to see that in Texas versus Johnson. So after O'Brien, there was a bit more clarity in terms of what was protected in regard to expressive conduct, but there were still questions, right? So other cases arose. So for instance, Street versus New York, also 1969, dealt with protest activity. And here we see a revival of the preferred freedoms doctrine, right? So this is the doctrine derived from Caroline Products footnote number 4. But there's no majority in Street versus New York. We wind up with a plurality decision. And as I've mentioned before, those send very weak signals to lower courts. Usually when you wind up with a line of cases that have a lot of pluralities, you're going to see more cases in that line because the court just hasn't come to any kind of consensus. All right, Spence versus Washington, 1974. We see another case of expressive conduct. And here it was kind of like equated with the armbands that were worn in Tinker versus Des Moines in the school speech case. But again, kind of like nothing definitive comes out of this case. So the next important case that comes up in the line of cases dealing with expressive conduct is Texas versus Johnson. All right, so Texas versus Johnson decided in 1989, but the facts of the case go a bit further back. So during the 1984 Republican National Convention in Dallas, protesters assembled outside of the convention. So one of the protesters, Gregory Johnson, decided as an act of protest to unfurl an American flag, cover it with kerosene, and then light it on fire. Right. So Johnson was arrested, and he was charged with violating the Texas flag desecration law. Right, so he was ultimately convicted and sentenced to 1 year in prison and a $2,000 fine. Johnson, of course, mounts a First Amendment challenge to his conviction. Now, as an aside, right, so this is again very similar to the facts that we saw 20 years earlier in O'Brien, but we see somebody here being arrested for dousing a flag in kerosene and setting it on fire. What's the difference between a flag and a draft card? Well, the draft card has a practical purpose to the agency that issued it, right? It, contains identifying information. It's part of the administrative system of the draft. Now, flags are different. Flags are kind of inherently expressive objects. They don't have another use, right? And in fact, the norms regarding most flags say that you shouldn't use them for other things, right? Like we would probably think that it was disrespectful if somebody took, like a South Carolina state flag out and decided to use it as like a, shrimp catching net, right? Flags have one use, and that use is expressive. This ends up being a really important distinction between O'Brien and Texas versus Johnson. So let's turn to this law. So the law that Johnson broke was specifically a flag desecration law. Okay, what does desecration mean, right? Let's just look at this word. Desecration literally means to make profane, right? To take something that is literally the word means to take something that is sacred and demean it or make it profane, right? So this is a law that has one purpose, which is preserving, let's just say, the dignity of a national symbol. So the legal question that arises here is whether state law that prohibits the burning of an American flag in and of itself, so on its face, violates the First Amendment freedom of expression. So in this case, we see a different result from what we saw in O'Brien. So the court found that yes, actually, this law does violate First Amendment freedom of expression. Now, that said, this was a 5-4 decision, so this is like not a slam dunk by any means. All right, so what are the important differences here? First, the court asks whether or not Johnson's conduct should be treated as expressive conduct, right? So should he be invoking the First Amendment in the first place? So if the conduct is expressive, then the next question is whether or not the state's regulation is related to the suppression of that expression, right? So this is them applying the test that they created in O'Brien. So if the state's regulation is unrelated to expression, then they can apply the less stringent standard, right? So that's intermediate scrutiny. However, if the state's action, in this case in suppressing Johnson's expression, is related to the message, then the court, because of O'Brien's test, or the test that came out of O'Brien, has to apply strict scrutiny. All right, so the court does this. They ask, what is the state purpose involved here? They look at the legislative history of the law that they're examining, and they find that the purpose is to promote national unity, right? Or to promote patriotism. Ultimately, this is not found to be a compelling state interest. All right, so this is a complicated case. I'm just going to take a step back. So the court looks at this. They say there is no way to look at a law that criminalizes burning a flag and say that that law doesn't target the message, right? The conduct is the message in that case. So this is not neutral in regard to viewpoint. All right, so if the regulation targets expression, this doesn't necessarily mean that that regulation is going to be struck down. The next step is that that regulation will now be subject to strict scrutiny, right? So this is the highest level of judicial scrutiny. The question with strict scrutiny is, does this regulation further, and I quote, a compelling state interest? And are the means used to pursue that interest the only means, are they necessary to pursuing that end, right? So this is kind of like the least restrictive means prong of the Sherbert versus Verner test. What is being asked of the government here is to demonstrate that it has a compelling state interest and that essentially they could not achieve that interest by less intrusive means. All right, so the next thing that the court moves to is refining their test for expressive conduct. So out of Texas versus Johnson, we see the court offer some guidelines for determining whether or not conduct is simply criminal conduct, or if, even incidentally criminal conduct is fundamentally expressive. So they ask the question whether or not there was a particularized message present. Additionally, what is the likelihood that that message would be understood by the audience, right? So we see some appeal here to intent, but also there's an expectation that the audience be able to, reasonably be expected to understand what the message is. Okay, so one of the key principles coming out of Texas versus Johnson is an emphasis on viewpoint neutrality, right? So the problem with this flag desecration statute was that it targets expression, right? And so the court finds that this was an attempt on behalf of government to suppress an unpopular viewpoint. And so in this decision, they reiterate the bedrock principle underlying the First Amendment is that the government cannot prohibit the expression of an idea simply because society finds it offensive or disagreeable. Here on the slide, I've boiled down the criteria that the court gives in the Johnson decision for deciding whether conduct is expressive conduct or if it's just simple conduct. So number one, does the person engaging in the conduct intend to convey a message? Second, is that message reasonably likely to be understood by an average person, right? Another question that the court may ask, but that isn't an integral part of the test, is the conduct inseparable from the message, right? So if, for instance, a government regulation interfered with the conduct part of this expression, is it less likely that the audience would understand what the message being conveyed was? All right, so all of this talk about burning things brings us to the next idea that we're going to cover in this voice thread, which is the notion of time, place, and manner restrictions, right? So, okay, the government, even if they are not looking to suppress somebody's speech, does have certain interests that they are required to promote, right? So, for instance, keeping order. This is a very basic one. Protecting public health. So things like preventing fires, these are like very basic functions of a state. These are kind of the things that you would expect the state to provide. But there are other important and compelling interests that the state might promote, right? So for instance, the state is in charge of not only providing roadways and sidewalks, but of maintaining them and making sure that they remain passable. So there are a lot of situations in which the government might need to weigh its interests against the expressive rights of citizens. These especially become important when we see things like protests or demonstrations, because those are the kinds of like public expression that have a tendency to potentially impede those government interests. So, for instance, in many cities, if you want to hold a parade, right, or a demonstration, you need to get a permit. And the reason for that is, if you're going to block a busy street, the state needs to make provisions for that, right? So they might need to provide police, to control traffic. They might need to make arrangements to reroute traffic around it. All these sorts of things that are kind of like, again, basic to the services that we expect the state to provide. All right. Now, so what I'm saying is that there are all kinds of restrictions that the state can legitimately put on expression that are unrelated to the expression. So we refer to these as time, place, and manner restrictions, right? So generally speaking, the state is free to impose reasonable time, place, and manner restrictions, even on, political expression. So time, right? This one's fairly obvious. If you're going to, say, drive around the neighborhood with a bullhorn, screaming about your political candidate or about the flying spaghetti monster, or whatever your cause is, you're more likely to be permitted to do this at 2 p.m. than at 2 a.m, right? So there would be a reasonable restriction on not allowing that to happen, right? In the middle of the night, because people need to sleep, right? They need to have a sort of like peaceful environment to go about their daily lives, etc. Now, place ends up being also very important. So, right, like there are scarce resources in terms of expressive spaces, right? So there are so many parks, say, in the city. There are so many streets, and these need to be allocated fairly for the use of all citizens, right? Sometimes for expressive uses, sometimes for more mundane uses. So the state can put restrictions on the place where expression can take place. So for instance, let's go back to the person who is proselytizing for the flying spaghetti monster, right? They can't necessarily go to the middle of King Street during rush hour and do that. They might be moved onto, say, the sidewalk, where they are less likely to interfere with traffic. And the same thing with manner. So if we look at, for instance, O'Brien and Johnson, we see cases of people burning objects for expressive reasons. Well, there are circumstances that might apply that could outweigh the expressive interests, even in Johnson, right? So if we take a look at Johnson and say, okay, well, we've got him dousing a flag with kerosene and lighting it on fire in front of the Republican National Convention, that's obviously expressive. But suppose we add another circumstance, which is to say that it's a drought, right? And there are a number of trees around, there's vegetation, it's dried out. In that case, we might have a different outcome with Texas versus Johnson if his burning of his flag were prevented not because of the symbolism of the flag, but because the city didn't want him to start a wildfire, right? So you can have, again, like reasonable restrictions that are unrelated to speech. All right, so here we see the different tracks of scrutiny. So I brought these up both with O'Brien and with Texas versus Johnson. So time, place, and manner restrictions are always going to be issues of weighing, right? So if this seems confusing, just bear in mind that these are ways that the court is going to approach weighing one interest against another. The first interest is the person's expressive interest, right? So their right to free speech. The second interest is the state's interest. Now, generally speaking, for types of expression that maybe are not considered as fundamental, right? So the example I give here is Arcara Books. Arcara Books was, this is a case dealing with the distribution of pornographic materials. And it had to do with creating an environment that was hostile to host or to keeping open a bookstore that distributed these kinds of materials. Well, the court looks at this, they weigh how important the expressive interest is. They say this actually has relatively little social value, right? We're not going to say it's utterly without social value, but there's relatively little like social or political value to this kind of bookstore being open. So we don't see like a fundamental liberty interest in expression being implicated. So we're just going to apply the lowest level of scrutiny, which is regular scrutiny. So this is in other contexts referred to as rational basis scrutiny. But the language of this is that the state merely has to have a legitimate interest in imposing whatever action it's imposing. Or I'm sorry, okay, so if it imposes action, that action has to further just a legitimate interest. And the restriction on the speech has to be reasonably related to that interest. This is a really low bar. So in terms of identifying a legitimate state interest, it really does, you just have to make a sort of reasonable case, right? Or the state just has to make a reasonable case. In terms of regular scrutiny, this almost always goes in the state's favor. And so in terms of it being reasonably related, it just has to not be a completely arbitrary action on the part of the states. All right, so second we see track 2. This is sometimes referred to as like intermediate or heightened scrutiny. This is kind of a default for time, place, and manner restriction evaluations. So again, the court is going to weigh the state's interest against the expressive interests of whoever's freedom of speech is being impinged upon. And they're going to ask, okay, is there an important state interest at play here? And is the restriction on that speech significantly related to pursuing that important state interest? Now, this level of scrutiny will be applied to expressive conduct cases if it is found that there is no viewpoint discrimination, right? So if there's no like message being either favored or suppressed, you're probably going to see intermediate scrutiny used. So we see this used, for instance, in O'Brien, right? So this is sometimes in Clark versus the Society for Creative Nonviolence, referred to as the TPM test. Okay, you're not responsible for knowing that, but we'll talk about that in just a second. So generally, this is what's going to apply. So intermediate scrutiny, as long as there is no viewpoint discrimination going on. Finally, we see strict scrutiny. So this is fairly rare to see this applied in expressive conduct cases, but the question here is there a compelling state interest at play, right? So this is the very basic activities of the state. So things like protecting public health, keeping order, preventing destruction to property. So is there a compelling state interest at play? And is the restriction on speech absolutely necessary to achieving that interest? This is the level that we saw applied in Texas versus Johnson. And again, the reason why they chose strict scrutiny in Texas versus Johnson was because it was determined that the regulation in question, so this was the flag desecration law, inherently targeted the message, right, of the expression. Another question to consider is where the expression takes place. Now, just as a caveat, you're not going to be responsible for knowing everything about the public forum doctrine for this case. I mean, sorry, for this class, if this class were only on the First Amendment, we would spend a lot of time talking about public forums, but we're covering a lot of stuff in this class as it is, and this is complicated. So I'm just going to give you a basic overview. What you do need to know for this class is just understand what is and is not a traditional public forum, and recognize the level of scrutiny that applies in a traditional public forum. Okay, so a lot of the cases that we have looked at in our freedom of speech section took place in public forums, right? So Debs, Abrams, Brandenburg, Ohio, Johnson, all of these involve some kind of public demonstration in a public forum, and specifically in a traditional public forum. So we see demonstrations or speeches or the distribution of leaflets taking place in parks, sidewalks, streets, in front of public buildings. So these are all traditional public forums. In a traditional public forum, the court will generally subject any kind of expression taking place there to strict scrutiny, right? And the idea being that there are supposed to be places where citizens can engage in expressive activity without being interfered with by the government, right? And it's important that these places be public because often, for instance, political expression means that you need to be able to reach other citizens. So saying, sure, go ahead, say whatever you want in the privacy of your own living room really isn't sort of serving the purposes of the First Amendment, which is to, in a meaningful way, protect free speech rights for citizens. So the idea behind this is that there have to be places where there are very few restrictions on public expression. So those spaces are traditional public forums. All right, so interestingly, in Reno versus ACLU, which is one of the cases that you will read for the obscenity and child pornography portion of this unit, the court extended some protections of the First Amendment to material posted on the internet. So this is an ongoing debate. You'll see this come up periodically. What is the internet? Well, currently the internet, broadly speaking, is treated as a traditional public forum. Now that said, specific sites on the internet, like Twitter or Facebook or Reddit, are not necessarily going to be treated like public fora or forums. And specifically, Twitter and Facebook are not treated that way because they are privately owned businesses. There have, however, been some efforts to have these treated as traditional public forums on the argument that, the idea behind a traditional public forum is to promote all sorts of viewpoints in the places where people spontaneously gather, right? In 2020, people don't really spontaneously gather in a marketplace anymore, right? Like we just don't really have open air markets in our parks. How often do you really see people in parks, right? Not that often. And so the argument goes, well, the way that parks and streets and sidewalks used to function is now how Twitter functions, right? So if you want to have a political discussion, do you go to Marion Square? Probably not, right? Do you go to Hampton Park? Probably not. You probably go to Twitter or Facebook or Snapchat or wherever, you young people go. So there's been a push to treat certain privately held forums on the internet as traditional public forums. So far, that has not been successful. However, the court has shown a willingness in Reno versus ACLU to treat the internet itself broadly as a public forum. All right, so as I said, you're not going to be responsible for knowing all of the ins and outs of public forum doctrine for this class. I do, however, expect you to have a pretty good grasp of what a traditional public forum is, because we'll see this come up in so many cases and it ends up being a relevant fact. Okay, now that said, if you're just really into public forum doctrine or you're interested in this, there is on OAKS, under the supplementary materials, a public forum cheat sheet that I wrote up basically for people to refer to. All right, so more generally, there are three types of public forum. Okay, again, these are all spaces. I'm going to start with the traditional public forum, right? So I've said a fair bit about this. Public parks, sidewalks, right? So there have been cases actually dealing with expression on sidewalks. yeah, McCollum versus Coakley, for instance, it's in your textbook. Now, again, these are places where in the past people have spontaneously gathered. These are also spaces that are both created and maintained by the state. You're not going to see, I'll just say it's very, very rare that you would see any privately owned space treated as a traditional public forum. Again, if you're just really into public forums, I can refer you to cases where that's happened, but those are exceptions, not the rule. All right, so these are places that have traditionally been open to political speech and debate. Expression that takes place in a traditional public forum is generally subject to strict scrutiny, right? So there must be, if the state is going to interfere with that expression, there must be a compelling state interest, and whatever means they use must be necessary to achieving that interest. All right, so in terms of public forums, the state cannot close these unless there's an emergency, right? So, maybe the state doesn't like that maybe we're having tons of protests, right? So the draft is reinstated, which everybody thinks will never happen, but they thought that before Vietnam too. Okay, let's say the draft is reinstated. It's very unpopular. People are protesting in the streets. Well, to prevent that, the city of Charleston can't just go close down all the streets. Same thing if people are, demonstrating in Hampton Park. The city of Charleston can't go shut down Hampton Park, especially not for the purposes of suppressing that expression. So your protections are very strong in a traditional public forum. Second, we have the designated public forum. Okay, so this is a space that is created by the government. Usually traditional public forums are created by the government, but they might not be, right? They might just be something that even sort of like predated the city. So like marketplaces are often that kind of place, right? So people gathered there before maybe the city was even incorporated. But a designated public forum is a space that is created by the government for some kind of expression. What are examples of this? Well, municipal theaters that are run by the city, large meeting rooms at state universities. So the theater actually here at the College of Charleston would be a great example of a designated public forum. So the government creates these, but the government is not under any obligation to create them. And they're also not under any obligation to keep them open, right? So the government can turn around and close any one of these for any reason that they want to, tomorrow. That said, there are some limits on what the government can do with the designated public forum, even though, the government created and maintains them. So they can close them if they want to, but they can't show any viewpoint discrimination in terms of who they give access to that public forum, right? So if, for instance, you've got, let's say at a college, a large meeting room that is periodically loaned out to different groups on campus. Well, the college couldn't say, yes, college Democrats can meet there, but no, college Republicans can't. If they're going to give access to one viewpoint, they have to give access to the other viewpoints. All right, and then finally is the non-public forum. So these are spaces that were created, again, by the government, but they weren't created for expressive purposes. So examples would include military bases, right? The government is under no obligation to let you stage your, one-person play on a military base. The same with prisons and public hospitals. These are spaces, again, created by the government, not necessarily intended for expression. And so the government has a lot of control over who can have access to them and why, right? And generally, these are not available for expression. All right, so this concludes our overview of time, place, and manner restrictions, expressive conduct, and types of public forum. So we're going to see the ideas covered in this voice thread popping up periodically throughout the various freedom of expression cases that we're looking at, but especially be on the lookout for these ideas when you see a case involving, a demonstration or a public speech of some sort, because these things like the time, place, and manner restrictions and the public forum rules will often come into play.